Senator, thank you. I have, as requested, prepared a little less than 10 minutes of remarks, and I know I'm not in my courtroom, so I don't set the procedures. I'm very sorry that Senator Kennedy has left, but I hope that I can today, in whatever time might have been ceded to him if he remained, address some of the inaccurate statements he made, rather than doing that exclusively in writing, if time permits. But I do thank you for requesting my testimony about how the Judicial Conference of the United States in the past discharged its responsibility under the 1978 Ethics in Government Act that applies to all federal judges, including Supreme Court justices. I am testifying as an individual, not as a representative of the Judicial Conference or the federal judiciary. I would like to highlight some of my lengthy written testimony in a further effort to be helpful to you and to the Judicial Conference. The Act codifies the belief that sunlight is the best of disinfectants. Transparency of financial information of a justice or a judge in his immediate family encourages justices and judges to decide cases impartially, as we are sworn to do, and encourages reasonable people to believe that we are doing so. The Act creates criminal and civil penalties for willfully falsifying information or willfully failing to file required information. In addition, 18 United States Code Section 1001 makes it a crime punishable by up to 5 years imprisonment to willfully falsify or conceal information. The Act defines a specific and limited role for the conference. It provides that the Judicial Conference shall refer to the Attorney General the name of any individual it has reasonable cause to believe has willfully failed to file a report or has willfully falsified or willfully failed to file required information. Reasonable cause is analogous to probable cause. It's more than bare suspicion, but less than by a preponderance of the evidence. It is not the conference's duty under the Act to determine whether a justice or judge has violated the statute. The conference is to decide whether there is reasonable cause to believe a willful violation occurred. If reasonable cause exists, the conference must refer the justice or judge involved to the Attorney General. This division of responsibilities is wise and important. I was a conference member in 2011 and 2012. Thus, I shared responsibility for assuring the Act was properly implemented and enforced. In 2011, the conference received 5 letters, and the Supreme Court received 1, in part alleging that from 2003 to 2009, Justice Clarence Thomas did not make the required disclosure that the Heritage Foundation employed his wife. I believe for many years he checked that her employment was none. The justice evidently knew of the requirement because he had previously disclosed his wife's employment, including in his early years as a justice. Although the Act does not require disclosure of the amount of compensation, the letters stated her compensation was substantial. The first letter was sent in January 2011 and was referred to the conference's Committee on Financial Disclosure. Justice Thomas promptly amended his reports, stating that he misunderstood the Act's requirements and that the errors were inadvertent. Nevertheless, the conference still had a duty to decide if there was reasonable cause to believe his omissions were willful, and if so, refer him to the Attorney General. Policy of the conference required that committees' reports to the conference include all their activities since the last biannual conference meeting. This information ensured that each conference member had the knowledge and ability to require discussion and possible decision by the full conference. However, the Financial Disclosure Committee's reports for the March and September 2011 conference meetings did not reference the issues concerning Justice Thomas or any related committee activity. The rest of the letters to the conference amplified earlier allegations, questioned whether Justice Thomas's omissions actually were inadvertent, and raised other concerns, including allegations that Justice Thomas had failed to report travel on Harlan Crow's jet and yacht. Those letters were sent on or after the date of the September 13, 2011 conference meeting. In early 2012, I found some of the 2011 letters on the internet. I told Judge Thomas Hogan, Secretary of the conference, that I was concerned that other conference members and I had not been informed of the letters in their request to refer Justice Thomas to the Attorney General. I suggested that the matter be discussed at the March 2012 meeting. He told me that he had referred the letters to the Financial Disclosure Committee and asked me to wait until the committee chair, Judge Joseph McKinley, responded to him. Judge Hogan subsequently gave me Judge McKinley's February 23, 2012 response. I spoke with Judge McKinley and became concerned that in 2011, the committee may have done nothing after Justice Thomas amended his reports and had not addressed the question of whether reasonable cause existed. Judge McKinley told me that the staff had not referenced the letters in the last 3 reports to the committee because they regarded them as routine. He also said, however, that this was the only time members of Congress or the public had ever requested a referral to the Attorney General. There was also no reference to the letters in the committee's report for the September 2012 conference meeting. Judge Hogan told me he had received an April 17, 2012 revised version of Judge McKinley's February response, and he wrote to the letter's authors on April 30th to inform them that the committee had decided against referral. I asked Judge David Santel, chair of the conference executive committee, to put the matters concerning Justice Thomas on the September 12 conference agenda. The executive committee denied my request. I then exercised my right to move the committee report to the discussion calendar. I told Judge Hogan that I would send a memorandum to conference members before the meeting explaining my concerns. He urged me not to include the 2 letters from Judge McKinley describing the committee's actions. I acquiesced and did not attach them to my memorandum. At the September 11, 2012 meeting, I moved to disapprove the committee's report and require revision of the prior 3 reports. Chief Justice Roberts allowed me to speak briefly about the deficient process and whether the conference was properly performing its important but limited role of determining whether reasonable cause to refer to the Attorney General existed. I hoped to generate discussion. When I concluded, the Chief Justice immediately recognized Judge Santel. Judge Santel successfully moved that the issues be returned to the committee for a report at a future meeting in which he knew I would not be present because my term as a conference member was ending. It is unfortunately relevant to consider these events now. The act only serves its vital purpose if the conference understands and properly performs its role. I believe that in 2011 and 2012, it did not. First, despite Congress and the public raising serious allegations and the conference referring them to the committee, it appears that the committee did little to nothing for at least a year. The committee should have, at the very least, addressed the allegations at the March 2012 committee meeting. Second, the committee's process was opaque. In 2011, likely through inaction, then in 2012, by insistence, the committee did not disclose to members of the conference the allegations, the actions, if any, it took, and the reasons for any decisions. Third, the statutory mandate for the conference, and by delegation to the committee, was to determine whether there was reasonable cause to refer, not the ultimate merits of whether the justice's violations were willful. However, in conversations, letters, and reports, the committee repeatedly framed its inquiry using the wrong standard. As I frequently tell my law clerks, if you address the wrong question, you're likely to get the wrong answer. Thank you.